In addition to the government or state forms required, as discussed in New Employee Documents Required Part 1, you should ensure you have some additional forms on file for each new employee you hire. You should have a signature page from your employee policy manual. That page should state that the employee has read and understood the manual. It should list the manual's effective date to be able to tie back to that edition. If you have employees that do not speak English, try to have a version in their native language. If it is only the occasional employee that does not read English, you can have a professional translator go through the manual with them and certify that the employee understands what their signature is agreeing to. By signing and agreeing to the employee policy manual, the employer has agreed in writing to your terms of employment. The manual can and should include a lot of information concerning your employment policies, your time off policies, your termination policies, and so on. You can include a dress code, smoking policy, jury duty policies, voting policies, and so on, almost without limitation. If you don't have a policy manual or a handbook, or can't prove that the employee read and agreed to it, you are at the mercy of the state labor law department and the courts if you and an employee disagree over the terms of employment. There are computerized systems and other services, including HR AnswerLink and others, that can help you write a policy manual that will hold up to legal scrutiny. You should also have a signed application on file for each new employee. This will, of course, list the employee's background, education, and other qualifications for the job. It should also give you permission to do a background check and to terminate employment if anything on the application is not true. Again, without this, if you find an employee has lied to you about their experience or their background and you want to terminate them, the State Department of Labor may force you to pay for unemployment benefits because you can't prove the employee lied about it without it being in writing. Some of the information you've collected in Part 1 and Part 2 is confidential, and you are required to protect it from disclosure. You should set up employee files and keep these documents in them. Lock the files up and restrict access only to the people that need access to do their job. How long you should keep this information and the forms you've collected on and from your new employee? There are some mandated minimum requirements for the various forms and no requirements for others. My advice is very simple. Keep them forever. If you really want a document destruction date because of space, then I suggest destruction no earlier than 10 years after the employee has left your employment, before you destroy the employee's file. Even then, I would scan them and keep them in a safety deposit box forever. It may sound excessive, but it sure is safe.